Good evening, this is Rahul Reddy. Every Tuesday, we bring in immigration updates with 1 hour, and we take live questions from Reddy Neumann P.C. Along with me is my business partner, Emily Neumann. Emily, what do we have today?
Today, we want to talk about October 1st. It's always a big day in immigration. It's the start of the fiscal year for green cards, also the start of all the H1B visas. It also creates an issue sometimes for F1 students transitioning to H1B because that is the end of your CapGap OPT work authorization. So if you are still having your H1B pending, it's in process, you need to be aware of that and know how that impacts your ability to work, what options you have in that situation. So we'll go through all of those scenarios. And another topic that's coming up more and more these days is what happens if you are maxing out on your L1A time because of the delay in being able to file your 485 in the EB1C category for those from India. What options do you have? How should you handle that situation, especially if you have time left, a lot of time left on your L1A? You want to start thinking about that now rather than waiting until 6 months before you hit your 7-year limit and then trying to scramble to figure out what to do. Also, we will be talking about changing employers if you're on H1B, you don't have any pay stubs. Is that possible? What are the potential issues that can come up in that situation? And lastly, if you are converting to B2 while you are looking for the job and you find the new job, can you return back to H1B? How does that work? What if the B2 is still pending? What if it's approved? Do you need to travel? So we'll answer all of those common questions that come up for those in that situation.
So as everybody knows that if the H1B has been filed between April 1st and October 1st, so for the change of status, and if the H1B is pending, they can continue working on October 1st. But if the H1B remains pending after October 1st, so they have to stop working. They could do a premium processing to avoid so that they could get the H1B. That means that if the OPT expires, let's say OPT expires in June 20th, and you file the H1B before the OPT expires, but right now the H1B is pending, you could have worked with change of status pending until October 1st. But from October 1st, you have to stop working. So you may want to get the premium processing done so that you can avoid the gap of employment a lot more than what is required. Emily, what other things where CapGap people need to be aware of?
Yeah, so if your H1B is already approved with the change of status, you should be able to easily transition from your CapGap OPT to your H1B. Be aware of your payroll taxes. You on F1, you are exempt from some payroll taxes. On H1, you are not, so you'll have to start paying those. So make sure your payroll gets updated accordingly for that. But other issues that come up if your H1B is still pending on October 1st, as Rahul said, your CapGap ends, you're not authorized to work, and you are also in your 60-day grace period of your F1 time. So if your H1B ultimately gets denied after your 60-day grace period has ended, so that would be after let's see, September 30th, November, December 30th, H1B is still pending and then gets denied after December 30th, you're immediately out of status because you didn't keep your F1 status valid with that. So you may want to consider re-enrolling in school, getting a new I-20 so that you can continue your F1 status if you're not able to upgrade your H1B premium processing. Another issue that comes up for those that already have the approval is what if you lose that job and the company is withdrawing your approved H1B? A lot of people think it's a good idea to have the H1B withdrawn so they can continue on the STEM OPT. Maybe they still have a year or two left on STEM OPT. That can be done. It creates some issues. Number one, your SEVIS record is likely already terminated or will be on October 1st because it thinks that your H1B is approved. And it is quite a hassle. It takes many, many weeks or months to get that corrected. And often they won't correct it until you actually receive the withdrawal confirmation from USCIS for your H-1B withdrawal, which takes months to process for some unknown reason. So you're going to be in limbo for months if you go that route. But you may also have the opportunity to file an H-1B transfer on October 1st, even if you aren't working for that company that sponsored the H-1B, depending on those situations. So you have some options in that scenario, but you definitely need to take care in making sure that your status is managed during that time.
Well, one thing people also need to understand is that if the change of status has been done, and if you are married, you need to make sure that if your spouse is a dependent on you, let's say you are an F1, your wife is an F2 visa, your wife will go out of status if the H4 has not been applied. Now, if it's been applied along with the H1B, that's fine. Otherwise, you can apply this week itself so that they don't go out of status. This also is applicable for the people who move from other statuses, for example, L1 visas or other visas, and their spouse is on a dependent, spouse and or children are dependent visa. You need to apply for the H4, otherwise they're going to go out of status. Please be mindful about it. Please take care of these things before October 1st, not after October 1st. Emily,
right,
on the
go ahead.
second topic of L1A max out, as we know that EB1C is backlogged all the way to 2022, and maybe it will be backlogged a little bit more. Now, unlike H1Bs, where if the I-140 has been approved, they can extend the H1B, but in L1, there is no provision. If the L1 expires, which L1A, which max out is 7 years, if the L1A expires, and even though they have an EB1C I-140 approval, they couldn't file the 483 application, the priority date is not good. What are the options according to your opinion?
So similar to an H-1B, L1s can also recapture time spent outside the U.S. So if you are consistently traveling outside the U.S. for work, any time that you spend outside the U.S. you can add that to your 7 years that you've already spent in L1A time to buy some extra time to hopefully be able to file the 485 before you actually max out. We recommend for our employers that use the L to go ahead and submit H-1B registrations in the lottery. Because if you convert from L1A to H-1B and you have that approved I-140 in EB1, you can get the H-1B extensions beyond the 6-year limit, even if you couldn't get the L1 extension beyond the 7-year limit. But you have to do that, possibly a number of times because the lottery is not as easy to make it through as it used to be. It's the chances of making it in the lottery each year seem to be getting lower and lower. You also could potentially change status to any other type of visa that you might qualify for. Maybe your spouse happens to be on H-1B. You could file a change of status to H4 and hopefully an EAD if your spouse has an approved I-140. Depending on how long that delay is to be able to file, possibly a change of status to B2 or F1, maybe even O1 if you can qualify. There are options, but you definitely need to plan ahead and start thinking about it when you're in your 3rd or 4th year of L1A time. Don't wait until you're in your 6th year to start thinking about what to do.
There's also F1 and B2 options that you can choose. Of course, you have to be mindful whether your company is going to cooperate you. Now, you can go back to your home country and transfer your green card application so that you can get the green card in your home country too. But all these things, be mindful that your company that you file the I-140 is going to cooperate with you in extending these offers to you. So please make sure that you're in good books with the company and good books with the HR and good with the books with the immigration of that particular company so that they cooperate with you in getting you and your family the green card though. Also, if your child is coming near 21, you definitely may want to consult an immigration lawyer to see what are the other alternative options. Now, even if the child moves to F1 visa though, they can always be included in the application if they are under 21 under the CSPA Act. Let's go to the next topic, Emily.
All right. Yeah, so can you change employers if you're on an H-1B but don't have any pay stubs? How does that work?
You can try. Definitely, they should try. Especially, we see some of the people who are coming from India, and they found that after coming to United States, they found that the company is not offering them the job. They call. A lot of people will call. I normally there are a couple of different options available. Let's say, for example, you are in company A. You don't. They are not paying you on the paycheck, and you are not employed with them. So what are the options? Since the H1B is not been withdrawn, the job is still there with the company, though they're not paying. It's actually the company that is violating. However, the immigration views that you are violating the status. Now, when you apply the change of employer from company A to company B, since you don't have a pay stubs with company A, company B H1B approval may come without the I-94. So that means that you may have to go outside the country, and sometimes in some instances you have to get the stamping. Assuming if your stamping is still valid though, I may choose to file a consular processing with company B, get H1B approval with company B, and then just go to Mexico and come back. Even though your company stamping, your H1B stamping is with company A, you can still use the company A's H1B stamping with company B's H1B approval and come into United States. That's one of the easy solutions that you have. Sometimes there are deadbeat companies. You work for the company, they don't pay you the money. You can do one thing. You can complain to the Department of Labor. The form is called WH4, Department of Labor. You can complain to the Department of Labor that the company is not paying you the salary, and file the H1B transfer to company B. And when they ask the evidence, hey, where are your pay stubs? You said, look, I am not in violation. It's the company that is in violation. I already reported to the Department of Labor. Here is the evidence that I reported to the Department of Labor. Make sure you keep the FedEx tracking number or email you sent to the Department of Labor so that you can have a tracking to provide the USCIS and request the USCIS, look, I am maintaining the status. It's only the company that's not cooperating. Please go against the company, and I should be granted the change of employer to company B. So those options are there. Anything else, Emily?
Yeah, there's also a provision called a nunc-pro-tunc extension request. So the normal rule is you always have to show that you're maintaining your status up to the day of filing, or if you're in your grace period, your 60-day grace period, up to within 60 days of filing. But if you don't fall into that situation, you have the option of asking USCIS to excuse what they consider a late filing of a change of employer petition, due to extraordinary circumstances that were beyond your control, beyond your new company's control. The delay in filing was commensurate with the circumstances, and you've not violated your status in any other way. So it's up to the discretion of the USCIS officer. So you need to explain exactly what the situation is, why you don't have those pay statements, and also be able to show how long you have been in that situation. It's much easier to get a nunc-pro-tunc extension approved if you took action immediately after you realize there's a problem with the company or the problem with getting paid, versus hanging out for 6 months with your head in the sand, not dealing with the situation, and then trying to do a nunc-pro-tunc request. It becomes much more difficult. They're less likely to approve that. So depending on the exact situation, that might be an option. But most importantly, please, whatever you do not even consider creating fake pay statements to provide to your new employer to file a transfer. I've seen people try to do that. That is fraud. That is misrepresentation. That is submitting fake documents for an immigration benefit that will make you inadmissible, meaning you cannot get an H-1B visa, you cannot get a green card. It's very difficult to waive that ground of inadmissibility. So do not, in desperation, take that kind of step.
One of the other things that I would advise for the people who are stuck with these kind of deadbeat companies is it's not going to get better if you continue staying. It's better to resolve the problem immediately rather than continuing with that company for a long period of time. It's going to get only worse. It's not going to get better.
All right, last topic is for people who maybe lost the job, their 60-day grace period is not long enough, so they filed a change of status to B2, which USCIS has allowed us to do for quite some time. They've been approving those. What is the next step to return to H-1B status once you do get that job offer?
once they get the job offer, the company can file a change of status from B2 to H1B, and the H1B will be approved with the I-94. If there are some company lawyers, I don't know where they're getting the impression that from B2 is pending, they won't get the H1B approval with the I-94. They're filing the consular processing. That is the wrong process. Even though B2 is pending, you can apply the change of status. USCIS is approving the change of status. We have had no problem moving from B2 to H1B, even when the B2 is pending or when the B2 has been approved. If your company lawyer is telling that they cannot do, please show them this clip of this video so that they can get aware that you can move from B2 to H1B. Absolutely no problem. The only catch point, I would say two catch points here, is that you can't start working on the receipt notice. You have to wait until the H1B is approved. The second catch point is that the company has to file the H1B in premium processing. If they file in the normal processing, it may take up to 6 months for you to get the H1B approval, which is not a good idea. They have to file the consular processing. That is a better idea.
All right. Time for questions?
Kalyan Kumar from Facebook is asking the question. Hey, my max out is 2026. If I fall under EB1C, what should I do? Well, we discussed that option from about 5 minutes of this video to about 12 minutes of this video. We discussed the options there. I want you to look into those details. That's the reason every week we bring in these immigration updates so that we cover the topics where we feel are important. We have this YouTube channel. We have a daily conference call. We get a lot of feedback from the people. Based on that, we pick the important topics and discuss it. Please watch the 5 minutes to about 12 minutes of this video. We addressed all those issues. Kalyan.
Arjun says he is from India. He's got the EB1C. Priority date is current because he's porting an earlier priority date. The attorney is getting ready to file the EB1 I-140 in premium and the 485 concurrently. And he wants to know if filing concurrent is better versus standalone. Based on my experience over the last 2 to 4 years in these situations, I think it is better to file standalone I-140 and then file the 485 once the I-140 is approved. I have had cases where, because when we file together, they end up at the Texas Service Center, and the Texas Service Center doesn't process 485. So your case just sits there until the I-140 gets approved, and then they take their sweet time transferring your 485 to the National Benefits Center, or they transfer half of your family and the other half is stuck in Texas. I've got that going on right now. You may not get your biometrics for your 485 because the case is stuck in Texas. I've got that going on with another case. So I think the 485 is processed so much more smoothly when your I-140 is already approved. Everything is handled by the National Benefits Center. Now, that would change if for some reason your priority date is about to retrogress and you might miss filing if you wait for the I-140 approval. But if your priority date is going to be current for some time, you may be better off just filing the I-140 right now.
Question from Kala. What's the fee structure for the, I'm an H1B, I want to move from H4 plus EAD. What's the fee structure? We don't give fees, but we have a very fixed fees. We are very reasonable. I wouldn't say that we have the cheapest one, definitely not, but we are very reasonable fees. You can drop an email to info@rnlawgroup.com and I will send you the details of the fee structure for the H4 plus EAD. Now, a lot of people are hesitating, Emily, to move from H1B to H4 EAD. There are two main misconceptions that they have. The one main misconception is that once they file the H4 plus EAD, three main misconceptions: that the H4 and EAD will not be approved together. They can't file the H4 and EAD together, which is not right. You can file the H4 plus EAD together. The second misconception that they have is that once you file the H4 plus EAD, they have to stop working on because they filed the H4. Not true. You can continue working until the H4 is approved. When the H4 is going to be approved, your EAD is going to be approved anyway. So you don't need to have a break in the job when you move from H1B to H4 plus EAD. The third misconception they have is that once you move to the H4, they cannot come back to H1B at a later date. they will have to go to the lottery system. Not true. If you have any time left over in the 6 years of H1B, you can always come back to H1B without going to the lottery in the next 90 years. Why not 91 years? You won't be alive by that time, according to me. And if you are, you come back to Reddy Neumann Brown, I won't be alive. Let Reddy Neumann Brown face the problem. Now, I won't be there for sure. So you can always come back. Now, there is also one trick where people are very misunderstanding on H4 plus EAD is that they think that the labor and I-140 cannot be filed while on H4. Is that true, Emily?
That is not true. That was what I was just about to add. Yes, your labor certification can continue. Your company can start the labor certification. You can file the I-140, even though you're on H4 EAD. There's no requirement that you be on an H1B in order to be sponsored for the green card.
Okay. Bautik has this question. Currently an EB1C, question on EB1, currently an EB2, I-140 approved. Can I move to India, but still be on the US payroll and manage the function of the team in US and come back, file an EB1C? First thing for Bautik, if you want to consider to be an EB1C, you have to be on the payroll of the foreign company. You cannot be payroll of the US company. You have to be payroll of the foreign company. Now, what about the team though? Does the team has to be India? We have noticed, surprisingly, the USCIS is not objecting if the team is anywhere in the world for the company though, which is a good news for you, is that you can still manage some of the people in USA and still be eligible, but you have to be on the payroll of the Indian foreign company. You cannot be the payroll of the US company.
Gunnison says, I'll be traveling to India next month. I have the stamped visa from my previous company until 2026. Should I go for stamping again, or can I use this visa? And what should I say at the port of entry? So assuming this is the same type of visa, like you're on H1B with company A till 2026, and you filed a transfer to company B and got that approved till 2027, no issues at all. You do not need to go for stamping again. Your visa remains valid until it expires. So you can use that visa stamp that has your old company's name on it and the old end date on it to travel back into the US anytime up until it expires in 2026. You don't need to say anything in particular at the port of entry. You just show that visa and your new I-797 approval notice. And make sure that they give you the end date that's on your new I-797 approval notice, not on the visa. Sometimes they mess that up, but definitely no issues with traveling with that visa.
Srinivas Vijay has this question from Facebook. His child, who is H4 visa, wants to pursue the medicine option in the United States. What are the options? Once, because everybody he knows and everybody knows that at the time of 21, the child has to convert into F-1 visa. Does he need to convert into J-1 at a later time? What are the better options? Very good. I want to explain very details about it, and Emily can add the things. And the best definitely is that you have to move to F-1. You don't have an option to move into F-1 visa once the child turns into 21. When it comes to the medical residency, though, the medicine is different. There is either you will do the medicine combined with the bachelor's degree, or you do medicine after the bachelor's degree. Either of those things you have to convert into F-1 visa. You don't have any other option because you're going to turn 21 by the time you complete the medicine. So after completing the medicine, though, the residency thing, there are two kinds of things. There are some residencies which the universities may sponsor H1Bs, and these H1Bs are exempt from the H1B numbers. But most of the universities don't, most of the medicine residencies, they don't sponsor the H1Bs. You will have to move, the child has to move to J1 visa though. As a lot of people may or may not know, that the J1 visa is easy to get in, but it's very hard to get out of it. Because to get out of the J1 visa, you have to go to your home country, maintain 2 years of home residency, and then you will be allowed to get on a H1B or any other visa to come back into the United States. Now, previously, India used to, be fine, liberal in allowing the people to not to get the waivers and other things. But right now, India is very strict; they are not allowing. So, but there are some exceptions for the people who are on J1 visas, where they can get away from the 2 years home residency requirement. At the same time, they get the H1B without going through the lottery system. At the same time, this is not, they can convert that into for-profit H1B at a later date. That is what we call it as one bullet and three birds. You're getting the J1 exception, you're getting the H1B, you're getting the waiver for the H1B lottery system, and still go to the for-profit organization, where your child will work in a rural area for a period of 3 years on a H1B. And that rural areas are exempt from the H1B numbers. And from there, after the 3 years, you want to convert into some private clinic, you don't go through the H1B lottery. So you're getting all three things done, what we call it as one bullet and three ducks. You're going to hit three ducks. That's your advantage by going to working in the rural areas. And after that, of course, they can come into H1B and file an I-140 in the green card, hopefully so eventually, and they may be eligible for EB1. But this is the normal route we normally tell people is to F1, J1, and go to the rural area and convert into H1B. Those are the better things. Now, is it advantage even if the universities or medical residences are offering H1B? Sometimes it may not be advantage to go through the H1B. Previously, sometimes it may not be advantage for you to go to the H1B. It may be advantage for the medical students to go to the J1. Then go to the rural area because everything will be solved at the second step. Anything else, Emily, and the medicine students?
No. PM says, what if I change jobs? Can the new company downgrade to EB3 using the 485J? And how can I wake up a pending petition once the priority date becomes current? So although the guidance from USCIS doesn't really suggest you can do it, we've definitely seen USCIS approve downgrades and upgrades using the 485J, even when it's with the new company under AC21. So the new company would just enter your EB3 I-140 receipt number instead of the EB2 I-140 receipt number, and then complete the rest of the Supplement J as normal. And the Supplement J also may be a way to wake up the pending petition when the date does become current if you're not seeing any activity on it. Possibly submitting your medical through an interfiling could be a way to wake it up. Otherwise, litigation can also be an option there.
Rajendra Kumar has this question from YouTube. He has a H1B with company A stamped in the passport. He left the company working with company B, and can he go to India without going? His stamping is still valid until March 2025. Can he come back without going for stamping before March of 2025? The answer is simply yes, you can. However, make sure when you enter into the United States, you show them the H1B approval of company B, not company A, and make sure on the online, the I-94 is reflecting with company B's H1B approval. Don't contact our office in April of 2025. Oops, Rahul, I did that, but my I-94 expired in March 2025. If you would contact by any chance, they do that mistake about 5 to 10% of the time. And if you contact any lawyer, your lawyer or us, before the I-94 expired, there are very easy solutions. If it's after and you contact us in April of 2025, it's going to be a big problem. So most of the time, they will do it until the company B's H1B approval, but make sure you check the I-94 and you come to our Zoom call. We have a daily Zoom call and show us the I-94. Hey, my I-94 is expiring this one, and we'll answer the question there too. And our daily Zoom call information is there. Link is provided there. There we are interactive. Here we are answering the question. There we are more interactive in the Zoom call.
Botic says, can we file the H4 and EAD if the perm and I-140 is still pending, or do we need that to be approved? So there's technically two ways to qualify for H4 EAD. The most common way is based on the H1B spouse having the approved I-140. So you wait till the I-140 is approved, and then you file the EAD by itself, assuming that the H1B and H4 are already extended. The other way to potentially do it is if the H1B holder has been granted a 7th year extension based on having a perm pending for 365 days or more, or the perm plus I-140 pending for 365 days or more. In that situation, the H-1B holder only gets a 1-year extension instead of the usual 3-year extension. So once that 1-year extension has been granted, then the H4 EAD could potentially get file the EAD at that time and get it for also just that 1-year period. I don't think in the 7 years since we've had the H4 EAD, no, it's been longer than that, however many years that we've had it, I can't think of one time where I've ever filed for someone who was filing it based on their spouse being granted that 7th year extension. It's pretty much always approved I-140, because that way you get it for 3 years and don't have to worry about the long processing time right away again.
Varaprasad has this question. His employer has recently filed Chapter 11 bankruptcy. He has a travel plan to go to India and he's going for visa stamping. Will there be an issue? As long as you have a stable job and you are getting the paycheck properly, though, you should not have any problem in getting the stamping. Bankruptcy, Chapter 11 bankruptcy is protecting the company, protecting the employees. So it has some protection. So just because it is filed a bankruptcy, Chapter 11 bankruptcy, doesn't mean that you won't get any stamping. But I will be very careful, because if you lose the job while you're outside the country, because when they're in Chapter 11, sometimes they may be forced to let go employees. The chances of layoffs are higher in that company. Then you may have a trouble. You can't go for stamping. You can't come back even if stamping is approved. You can't come back on that stamping.
V says, in H1B while on bench, if the company doesn't pay for a few months, will that affect my next H1B extension or renewal, transfer, green card filing? For sure. Yeah, that's not allowed. A company cannot put you on the bench and not pay you. That is 100% a violation of LCA requirements. The company is not in compliance, and that puts you out of status. And so don't stay in that situation. That's a bad company. You should not work for that company. Go find a new company. And as we talked about in the beginning, consider the new company filing a consular processing H-1B that allows you to exit and use your valid visa stamp to come back as soon as it's approved. Otherwise, you may have to file a nunc-pro-tunc or file a complaint against your employer as part of the H-1B transfer process. But definitely do not continue in that situation. The company is violating the rules. It's not a good company to work for. The longer you stay that way, the more difficult it will be for you in the future.
Question from Madhu Srinivas Shankaran. Can I file a H4 EAD for my kid who is 16 years? She likes to work. Absolutely not. Unfortunately not. Children are not allowed to have the H4 EAD. It's only the spouse that is allowed to have the H4 EAD, not the children.
SNH says, I worked in a managerial capacity in India for my current organization for 2 years before moving to the US, but that was 10 years ago. Am I still eligible for EB1C? Possibly. I've definitely done it in the last several years, given the backlog for EB2, EB3. Got a couple of them pending right now. But it depends on how you came to the US. Did the same company 10 years ago bring you to the US on an L1 and then you converted to H1 and you've been extending for 10 years, then yes, you can qualify, assuming that you have your US job is managerial as well. But if you came to the US 10 years ago on F1, then no, you don't qualify. So it only works if you came to the US to continue working for that organization. Then you can count the time more than 3 years ago.
Do you suggest, this question is coming from Akhil from YouTube, do you suggest EB1A I-140 applying in premium processing right away or wait for the receipt notice? Definitely file the premium processing in right away. I don't see any reason why you have to wait for the receipt notice and then file the premium processing. A lot of people are under the assumption that you have a premium processing, you have a high probability of getting the getting the RFE. We don't believe in it. The stat doesn't support it. The only thing it does is that you will get an expedited RFE because they are obligated to do it.
Arash says, my I-131 renewal was filed back in March 2024, but has not been approved yet. Can I expedite based on my close relative being hospitalized, or any other options? You can certainly try. Really depends on the officer. Expedites are completely discretionary, meaning the officer gets to decide whether it's a serious enough situation or not to cause them to give you that emergency advance parole. But litigation can be another option that we are using quite frequently to help people get the advance parole when they're pending for these unreasonable amounts of time.
Sasapu Ramanaidu has this question. He is on the receipt notice. He's moving from company A to company B. Now he got another opportunity to move to company C. So I don't know how long it's been that you left the company A. I don't know how long it's been you left the company A. But if it's been that more than 60 days that you have stopped working for company A, then if you move to company C with the receipt notice, there are some risks associated with getting the H1B approval with company C though. If it's only been 60 days since the time you left the company A though, then definitely you should not have any problem in moving to company C.
Josh says, I'm currently employed under my H1B visa. What are my options to participate as an equity shareholder in a startup that's being founded by a U.S. citizen friend? Absolutely, you can do that. You can be a passive investor. Equity shareholder, same thing. You can own a company. You can pay to invest in that company while you are on H1B. It would just be like going to the stock market and buying Microsoft stock. Yes, you own a portion of Microsoft, but that doesn't mean you're working for Microsoft. You're not doing anything that's without work authorization for them. So the same type of thing. You have no participation in what the company is doing. You are a passive investor. You give them your money, and if they make a profit, you take some of the profit. If they lose money, you've lost your money. Nothing beyond that. You should not be involved in guiding the company, working for the company in any way, showing up at their offices all the time. You need to stay out of the business because you don't want to be found to have worked without authorization because you don't have an H1B with that company.
Question from Deepak. What are the probabilities for the priority date to be correct, filing date to be current for July 2014? He's definitely speaking of either EB2 or EB3. I would say that very unlikely in the fiscal year of 2025 until about October of 2025. It's very unlikely. Hopefully, I'll go in wrong. Hopefully, some new administration may come. They may make some changes. Hopefully, there may be some law changes in the lame duck session, which we want everybody to be aware of what a lame duck session is. We will be drafting some letters at that point of time to contact the administration and or the Congress to make some laws at that point of time. Why is lame duck? What is lame duck session is that anything after the election of the president, by the time the new president comes in, this time we're going to get another president because Biden is not going to be is not a candidate for the presidency. It's either Kamala Harris or Donald Trump. So in between that period of time, the Congress still sits there, the old Congress, the old parliament sit there, and they can still pass the legislations. That's a very daring thing, and this president also is going out president. This going out president sometimes can do some drastic steps in formulating regulations or executive orders. So we'll see if any of those things can be done after the elections.
Sanjaya says, I'm preparing to file my adjustment of status, but there are high chances of a layoff. After filing the 485, can I switch to F1 status if I'm laid off? That may be tough because F1 at the time of filing the change of status, you have to demonstrate your non-immigrant intent, and having a pending 485 is definitely the exact opposite of that. That's pretty clear intent that you want to immigrate permanently into the U.S. So you are likely to get the denial of the change of status to F1 in that situation.
Question from, one second. Ganesh from YouTube. The question is, how long it takes for a person to get the green card if they file the 485 under EB1? Ganesh, first, I'm assuming that the priority date is still current. Typically, this is not all the cases. Anywhere between 5 months to about 8 months is the time that we see if the EB1 is current all the time from the time you file the application all the way that you get the green card. Typically 5 to 8 months is the time we see.
Sendil says, if my employer is firing a certain percentage, is this going to impact my 485 processing? Assuming you're not one of the ones included in that, no, it would not impact your 485 processing. It does impact the labor certification process. If people are going through that and have not filed the labor certification yet, and there are layoff situations, the employer may not proceed to file the perm labor certification, but you're at the ending stages there, it will not impact your 485.
Mir Akbar Ali has this question. Can I apply I-140 being an F1 status under EB2? The answer is clearly yes, you can. You can apply under the EB, you can apply under the EB2, an F1 status while you're an F1. You don't have to be an H1, you don't have to be an EAD. If the company has a job offer, they can apply well before.
MK says, my H1 was applied online and my dependent's H4 was applied through the mail. Both are in different service centers. What are the chances of the H4 getting approved along with the H1? Very, very less, unfortunately. Number one, they're not filed concurrently. So the only time USCIS bundles and approves together is when they're actually filed together in the same package. Yes.
Emily, there are a lot of times the lawyers are filing the application together, H1B, H4, and EAD. They're not giving the receipt notice from the same service center for the H4 and EAD, though. Mm-hmm. So if that is the case, you can notice it on the receipt notice date. H1B and H4 will have the same receipt notice date. If it is the same receipt notice date, though, even though the receipt notice numbers are coming from 2 different centers, though, it's actually been filed on the same day. The reason is that if the H4 has been filed separately, though, they should have a H1B receipt notice at least, or the approval notice to file a H4. So some of the people are confused. No, my lawyer sent H1B to a different center, H4 to a different center. No, they did not. They did file both of those things and they are giving the receipt notices. But you're right, Emily. The second part, when the H1B is given with a different service notice and H4 is being given with a different service notice, H1B is getting approved, H4 is not getting approved. They can contact our office according to the agreement between Iduki and USCIS. They're supposed to approve if the H1 and H4 and or EAD has been filed together. All 3 things should be approved together. You can contact our office and we can, once the H1B is approved, you can contact our office and we can get it rectified.
Yes, but that would not apply to MK's situation because his H1 was filed online. H4 filed separately.
Okay,
so yes,
no,
those
sorry,
will not be considered concurrent filings, so they don't qualify under bundling and they're not likely to be approved together.
Yeah, that definitely does not cover it. Sorry about that.
That's great.
What about the EB2 AO's timeline, the dates, 2011 priority dates? If you have filed recently, the priority date is current, yeah, they can still approve within 6 to 8 months though. Now, it's been a long time that your 485 is pending and your priority date is current. My suggestion to people is sue the USCIS in the court. That's the best option that you have. Because otherwise, these dates will move backward and forth, and it's not worth waiting and coming to this YouTube shows of Reddy Neumann P.C. It's always good to get rid of us as soon as possible. File the lawsuit against USCIS. Contact Stephen Brown in our office. Is the best guy to do all these things. And get rid of me and Emily. That's better.
Madhu says, can I file an H4 EAD for my kid? She's 16 and would like to work. Unfortunately, no, the H4 EAD is only for spouses on H4, not for kids. So yeah, it's definitely a problem for, kids on H4. They're not going to be able to do that summer job like all of their friends can do. That's why some people choose to switch to an F1 early on in their college to be able to get those the CPT in the summer and that sort of thing. But while on H4, no, not an option.
A question from GK. What do I do? My H1B expired. My 485 has been submitted, but the date is not current. With the same employer? I'm assuming that even though the priority date is not current right now, the priority date was current when the time you filed the 485 application. Now, if you have an EAD, even though your priority date is not current, but it was current at the time when you filed the 485 application, you can start using the EAD. Just because your H1B expires, your priority date is not current right now, even though it was current before, you're not out of status, you're in legal status. Now, if you have an EAD, which most probably you have, then you can continue working, absolutely not a problem. When people are asking questions multiple times, we are not understanding the question properly, guys. Can you try to rephrase the question so that we can get to it? Don't just copy and paste the same thing again and again. If you rephrase it, it will look much better, because sometimes we're not getting the question properly. B2 stay in United States is for 6 months normally. It's not for 180 days. So if the I-94 is given, you can stay until the end of the I-94, not a day afterwards. You can stay beyond 180 days as long as the I-94 is given, and less than 6 months, you're good.
Chanu says, my H-1B transfer with the new employer was already approved. The start date on my offer letter was October 1st, and the new I-94 is valid actually from September 9th. He wants to know, can he keep working for the current employer until September 30th? So in a transfer situation, you can keep working for your same employer and never join the new company. Just because they filed a transfer doesn't mean you have to join. And so, yeah, you can delay your start date with that company, but you're going to need their cooperation, because if you delay your start date and they get tired and don't want to wait anymore, they might just withdraw the H-1B. There are some companies that take a very, very restrictive stance and say that if you're not joining within 60 days of the start date, then they are just going to withdraw and terminate that employment opportunity, taking kind of the Department of Labor's wage and hour requirements a little bit overly restrictive. They're under the impression that they have to start payroll within 60 days in order to comply. That is a rule, but it's not the situation where the person is with another company and they have documentation of that, that it's the person who's wanting to join later. So they need to document it properly, but definitely it can be done.
A couple of questions. Question from Vinny Jain. If I travel outside with an approved I-1 for advance parole, and while I'm outside the country, the green card is approved, will it be a problem for me to enter back into the United States? Absolutely will not be a problem. You can take the 485 approval notice with the advance parole, and then you will be allowed to come back into the United States without any problem. Had this situation so many times, I'd never had any problem. Prasad has this question. This question is coming from many people, Prasad. He's asking about the timeline of the EB-1C. If he goes work outside the country for 1 year and comes back and applies for EB-1C, what is the best timeline? He's thinking about his child is going to be aged out. He's trying to avoid everything possibly for getting the kid into his application. Well, the time period, Prasad, I mean, assuming everything is going to work. Now, here, the main key point here is the company cooperation and your position qualification meets the EB-1C requirements. Do not forget these two things, though. These two things are very important. Assuming these two things are covered, the company is very good. the position there in India, outside the country in the United States, meet the EB1C requirement. Yes, you can work for 1 year period. It's not up to, it is 1 year period outside the country, and you can come back into United States and file the I-140 in premium processing. Now, most of the people like you, Prasad, I'm already assuming you already have an EB2 or EB3 I-140 approved, so you can port the date to EB1 application, which you already know. So at the time when you come back into United States, you can file an EB1C application. The day you land into United States, you can file an EB1C I-140. And since you're putting the date from EB2 to EB3, you can file a 485 application immediately. The child age freezes because I-140 is pending, and most probably I-140 will be approved and the 485 will be pending. So the child age freezes. So things can be achieved in a span of 12 months. So if you leave on September 25th, you can come back on September 27th of 2025 and file the 485. Ideal situation. But yeah, give or take, I would give some 3 months here and there. It should be 15 months. That if your company and you are very efficient in doing the premium processing and all those things, 15 months will be very ideal. But can things be achieved in 13 months? Yes, that can be achieved in 13 months too.
Kamal says, I'm expecting the perm approval next month filed by company A, but I have a job offer with company B and they're going to file the new H1B. Can company A still proceed with filing the I-140? It's going to be up to the company and whether they are still offering you that job in the future when you get your green card. So you don't necessarily have to be working for them right now in order for them to file that I-140 from an immigration standpoint, but a lot of companies aren't going to be willing to go through that additional process for an employee who's leaving them. So can they do it? Yes. Will they do it? Maybe not. If this is your very first I-140, you may not be the best time to change jobs. You may be in a better situation to file that I-140, wait for 6 months, and then take the next job offer, because then your priority date's locked in. You can keep getting H1Bs beyond the 6-year limit. Or if this is a situation where this is maybe a second I-140 for you, you already have your priority date locked in, well, then you don't need this I-140 at all. Go ahead and take the new job offer and start a new perm with the new company anytime in the future.
Question from Imran Ali. Finally, he rephrased the question. He's in B2. He entered United States. He has an approved H1B application with company A, which is not stamped in the passport. Now he has a job offer with company B. Can he change after 90 days after his entry to United States? Can he change to company B? Technically, Imran, since your company H1B is not stamped in the passport, though you are not counted toward the H1B number, so you would not be able to move to company B. I've seen sometimes where USCIS sometimes ignores the rule, but the general rule is that you cannot change the employer because your H1B is not stamped in the passport. You're not counted toward the H1B number.
Jim says, I was looking for the A number, but the employer didn't give me a copy of the I-140. But I applied for my H1 extension based on the approved I-140, and I see an A number on the extension. Is that the right one? It might be, but it might not be. Sometimes if you were on OPT, those EAD cards had what used to be called an A number on them. Now they call it a USCIS number, but some employers will list that number on the H1B as your A number. So it might be from that and might not actually be your I-140 A number. You can always get it by doing a Freedom of Information Act request to get a copy of your I-140 petition, and that A number will be stamped on there somewhere.
GK says that options of job change on I-485 EAD. I'm assuming you're the main applicant, though. If you're a dependent applicant, absolutely no restrictions, none whatsoever at all. If the dependent EAD persons can sell vegetables, can become a lawyer, can be a Microsoft CEO, or can flip a burger in McDonald's. I was a dependent 485 EAD. Well, I did Pizza Hut delivery, and I was also an immigration lawyer in that dependent 485 EAD without subject to the profession. Of course, if you are the main applicant, though, the 485 EAD restricts that your main job should be in that relevant field. It should be only, let's say, if you're in a software field, then you should be in the software field itself. Can you move from Java software to SAP? Yeah, it still is a software field. You can move from Java software to SAP, and you can change the job. Now, people ask the question, does the new company need to file an I-485J immediately? Absolutely not needed. The 485J can be filed when there is an interview or if there is an RFE. Otherwise, you don't need to file an I-485J. You can just get the green card, and that's about it. There's no obligation to file the I-485J immediately. Now, but it has to be in the relevant profession. That's all it matters for you.
V says, with Paystubs only until August 31st, can I go for a transfer? I'm assuming you mean H1B transfer. Is the September Paystub mandatory? So remember, H1B holders have a 60-day grace period when filing a transfer. So when I'm filing someone's transfer, I just look at, do they have pay stubs within the last 60 days? If yes, I can file the transfer. I don't have any issues. So if you have August pay stubs but not September, that's within 60 days. So it should be able to file a transfer under the 60-day grace period.
Sabarish is asking this question of EB1. This is Akhil is asking that EB1A, they're issuing a lot of RFEs if they file in premium processing. We don't agree. In general, the EB1A RFEs have gone significantly higher because there is a real high filing of the EB1As. That's a reason. In general, it is. It's going to get even worse as the time goes on. People are rushing towards EB1As. So just because you filed a premium processing, are people getting RFEs? We don't agree with that statement. We agree with the statement that since you filed the premium processing, you will get an RFE faster. That's what we agree on.
Sabarish says, my wife was on an approved I-797A and was working. I'm assuming you mean for an H1B. She traveled to India, had to come back on H4. Can she get another job and do an H1B transfer? So assuming she was previously on an H1B, she went through the lottery, and she's not used up her 6-year limit, yeah, she can have a new company file a change of status back to H1B and get however much time is left in her 6-year limit. She has her own approved I-140. The 6-year limit doesn't apply, so she can get a 3-year H1B. She cannot start working until the H1B is approved because it's not an H1B transfer situation. It's a change of status. Unless, of course, she has an H4 EAD, then she can work on that until it gets approved.
Question. You said that on the H4 EAD, company can file the green card application. When I contacted my employer, they said they can't. No, that is not true. The company can file a green card even though on the H4 EAD. Now, do they want to file the green card? It's up to their option. Can they legally file the green card while you're on the H4? Absolutely, they can. They can continue with the green card. They can file a fresh green card. They can file an I-140 when you're H4 EAD. Absolutely not required that you have to be an H1.
All right, well, I think we are out of time for today. Thanks everyone for joining us. As usual, we will be back next Tuesday live at 5 o'clock Central Time to give you the latest updates and answer your questions. Thanks for joining.
Thank you.